at a date, at a future date. Yes. So what is being contemplated, members, is that this date which is or will be set for the appearance of the JGRA, we will just accommodate them on that date. So we now move to the continuation of our clause by clause analysis. And Ministry, I'm inviting you to pick up from where we left.
Thank you, Chairman, and morning, members. We are supposed to pick up at clause 69. And as you had mentioned before, it is a document summary sheet of decisions made by the committee on clauses 52 to 74 that was presented at the previous sitting. So for clause 69, the decision was for it to be deleted. That was a decision from a previous sitting.
Could you just
the clause
bring us back? Yes, what was the original intent of clause 69?
The original intent of clause 69 was under the regime of having work groups in the workplace. And if you can recall from subsequent sittings, we had put forth a proposal that we be using safety and health, joint safety and health committees. So that makes this clause unnecessary. Because this clause speaks to work groups.
So, members, we agree to the deletion of 69?
Clause 69.
Okay, Member Brown, we know you're present. So you proceed to 70 now.
Clause 70, general obligations of persons conducting business or undertaking. At point 1 under decisions, clause 70 subclause 1A to be deleted as it is a duplicate of 48.2. The ministry will revert to the clause. And the response from the ministry is that we still have not yet completed the process as it relates to the deliberations and the suggestions. This clause is a clause that contemplates consultation, and there were some recommendations before as to how to treat with consultation. If you can recall, Member Gale was even mentioning that we could possibly look at a code of practice that gives guidance to how consultation should be treated with, and we are in the process of trying to put something together to that effect.
So it's not only the code of practice, but also to define consultation, because people use it widely for their own pecuniary advantage in terms of how it's defined. So we need to have a clear understanding as to what it means for consultation in this process.
Mrs. Celia Brown, would you comment on that? Okay, fine.
I have no issue, Chair, given in light the provisions of 48.2.
Okay, fine. But I think what I was seeking a comment from you on is that Member Gale is suggesting that a definition for consultation be looked at, and I do not know if it is meant here outside of its ordinary everyday meaning. So I don't know if you.
I don't know if it's necessary, again, in light of clause 48. And I don't think we're going outside, as you say in the normal meaning of the word consult. But it's something we can look at later on. But I don't think we need to define it.
Very well. Ministry?
For point 2, clause 70, subclause 2, to be reconsidered by the ministry was the decision, and we will...
No, that's a question. Before you go to subclause 2, now you're deleting 71A, but in terms of B, you keeping B as is? Is on the A you're deleting. But A, B speak about consulting with work in different work groups and so on. So is that okay as is?
We have to ensure that we reconcile what is set out in 70B with 48. So at the time when we are looking at 48, we will also be considering 70B, no, 71B.
Yeah, so what I'm asking then, for better order then, I think what would be better for the committee is to, because you're proposing to delete A, but if you have to rephrase B, 71A, but I would prefer probably a more comprehensive assessment would have been done than if you put to delete A, you're going to keep B in the same form or redraft. So at least we have a great, so we're going to revert again. So since we are on it, probably for better order, I would have loved to see how we reconfigure B in light of the deletion proposed for A. And it goes for all the others because it would flow from.
Yes, members, Kefri, we recognize that, and that is why there was a decision, point 6, clause 70, to be reconsidered by the MLSS. So for those others, we will be looking at them.
Also, you propose that complete deletion of A now, but reconsider all the others?
Yes, because of the duplication with 48 too.
Chairman.
Yes, Member Brown.
It's my understanding, Mr. Mahon, that you're not ready with 78, clause 70, so we ought not to be discussing it now, because we're going to come back to it again when they come back. So I suggest we pass on 70 until.
Yes. Yes. I share that view too, Member Brown. So let's proceed, Mr. Mahon.
Clause 71, exceptions from obligation under section 70, subclause 1. The decisions made were that 71.2 is to be deleted and 71 subclause 3 is to be revisited. This is speaking to AGC to do research and treat with the issue of bribery. But as said before, this is a response from the ministry, so we will have to await the response by the AGC.
Yes. Mr. Basco? Yes. Yes.
Morning, Chairman. So we did some research on the issue of bribery, and the committee will recall that when we were looking at 71.3, the concern was that the financial assistance, the ministry raised concerns that they didn't want it to be seen that the PCB was attempting to bribe. So we thought that if you look at clause 107, that concern of the ministry, and that's on page 79 of the bill. So clause 107 deals with prohibition of coercion or inducement, and we thought that perhaps the section or the clause could be further amended, taking some guidance from the Integrity Commission Act to deal with the acts of corruption, etc., from the Corruption Prevention Act.
So, Mr. Basco, what you're saying is that, or you're making a recommendation that further work be done on the 71.3 and guidance be sought from the Corruption Prevention Act.
I was suggesting that 107 is where we should deal with that issue because it deals with prohibition of coercion or inducement.
Okay, I'm clear on that. Do you, Mrs. Celia Brown, do you have a comment? Yes.
Two things. Not forgetting that we need to come back to 70 subclause 3 because there's no offense. We have not created any contravention, any prohibition in clause 70. So there's no offense to be committed in relation to subclause 3. So remember, we said we will come back to that and decide what would be the appropriate sanction, not necessarily a criminal sanction in relation to this provision. And I'm thinking in relation to what Mr. Bashko has said, we can probably subsume subclause 3 of 71 in subclause 107. Okay?
Very well. Members, any comment? No, it's a recommendation from the drafters that 71.3 be subsumed in section 107. Ministry?
With the appropriate
Yes.
Integrity Commission formulation, that's what I'm understanding.
Yeah, so, sorry, the reason Mr. Basco and I were having a discussion because he mentioned the Integrity Commission Act, which is correct. It's just that the acts of corruption are actually listed in section 14 of the Corruption Prevention Act. So the Integrity Commission Act actually refers you back to the Corruption Prevention Act. So, and the acts of corruption, there are many, listed throughout section 14 in various subsections. I'm not saying that perhaps you need to repeat all of them, but there would have to be consideration to see which ones you would want to bring into this legislation. Because remember, the Corruption Prevention Act / Integrity Commission Act wouldn't necessarily capture the persons who fall under OSH. That is really dealing with public servants. So you may need to now review to see what you think would be appropriate, it's in the line of bribery, but there are nuances with all the different types of acts of corruption, which actually we are compliant with international obligations in terms of how we have set out our acts of corruption. So it is really a very good guide that could assist the ministry in reviewing those to see what they would want to add to clause 107.
I didn't understand, yes, Mr. Basco to be saying cut and paste.
Yes.
But to be guided, which is what the Soldier is saying. And that's the understanding I have. I think we're at one.
Very well. Any comment? Further comment, Minister?
We accept the recommendation.
And members, we agree? Very well. You may now proceed.
Clause 72, obligation to train safety and health representatives. Point 1 of the decisions. 72, subclause 1, subclause B. Members had suggested that the training course should not be mandatory. The ministry is still of the view that at least a prescribed course as set out in 72 subclause 1B should be mandatory. The rationale for this is that if we're going to be having the safety and health representatives empowered to do some aspects of the monitoring and ensuring that the PCBU is complying with the minimum standards of the law, they should be able to recognize and evaluate and control hazards. And they are to have knowledge of the safety and health legislation. So we have to view that having a short course that will cover these will empower them and put them in a better position to be able to function effectively as safety and health representatives in the workplace.
Yes, Member Gill.
You know, so when you make a training program mandatory, it assumes that those who may participate may have to matriculate, or they may have at least some assessment to ensure that they qualify to do what you expect them to do. We may get into a situation where you have a particular workplace that the requirements are not of a particular education standard. And I speak of maybe persons in agriculture, for argument's sake, or construction, or anything. I don't want to single out, but based on our experience, now, it might be a little challenging for these workers to identify someone meeting the requirements of your technical training. And I just want the ministry to have that in the back of their mind when contemplating this particular requirement.
Yes, Mrs.
But Chair, from my reading of the provision, the course isn't mandatory. What is mandatory is the duty of the person conducting the business or undertaking to allow this safety and health representative to attend the course that he's entitled to attend pursuant to regulations. I'm thinking that the regulations would set out what are the prescribed courses, who is required to attend, but this doesn't say that the course is mandatory. It says that the PCBU must, if that request is made of him, allow them to attend whatever courses they're entitled to.
But what we're hearing is, that we have some clarification on that from the ministry. Mm-hmm. What are we proposing? Ministry, are you proposing that the course be mandatory?
Just to remind you of a document that was sent previously, and it was referred to as document 5A. The Ministry of Labour, Social Security policy changes for provisions relating to work groups, safety and health representatives, deputy safety and health representatives, and joint safety and health committees, January 6, 2020.
And that is document 5A.
We had put forth a proposal for a policy change at point 3. No, not point 3. Sorry. It's not. It's not in this proposal document. I stand to be corrected.
But what I understand, Mrs. Seeley Brown,
it was actually in the matrix. The matrix dated November 15, 2019, on page 27. For clauses 72(1), the ministry had made a recommendation that the prescribed course in clause 72(1)(b) should be mandatory. this was in response to a comment from the OCPC, which was stating that the marginal note refers to an obligation to train safety and health representatives. However, subclause 1 states that the training will be granted upon request. What is the intent of this provision? Should training be mandatory in light of subclauses 85, 6, and 94?
Mr. Chair, on that point.
Yes, Member Skeffer.
Well, the committee generally said that it should not be, and the ministry is still believing that it ought to be. But how would you enforce that mandatory provision? Yeah.
We were only asking that question because of the powers. Remember, and this was discussed in another meeting, the powers that you were given to the safety and health representative under clause 85. But I think all of that is going to change somewhat now, based on other discussions that we've had. So we were only asking that question in light of the fact that you're empowering them with certain functions and duties under 85 that I think we have discussed and we have decided in some way that we're going to amend. So just be caution in relation to the comment that OPC has made.
Very well. Yes,
so I'm saying if you want to make the provision mandatory, how do you enforce it? First, A. And I ask in the light and put it in context. Remember that the SHR are elected by their peers. So you can hire them and you can fire them. Am I right?
Correct.
So if this person refuses to go to a course, it will be a criminal offense? How do you enforce it?
No, it won't be an offense for this person not
so
to
the
attend
person
the
does
course.
attend. So it's mandatory, but I refuse to attend. How will that person still be able to act in the position? And if not, how will you remove the person?
We are not saying that the person will not act in the position, but what we are trying to do is to give them that empowerment that they will be able to be trained in a manner that would allow them to.
No, I am not opposing training. I understand the importance of it. But if you are making this mandatory and I refuse, then what next? So I want to understand how you apply it practically. Because if something is mandatory, and you don't carry it out, then there must be a sanction. That's why the committee, in my own view, as I recall, was not going down that road because we didn't see how you would enforce it. And you are saying to me that even if I don't attend, you are not seeking to remove, you're not preventing the person from representing the workers. So why making it mandatory in that context? Right? And how do you apply clause 84 to that?
Yes, Mrs. Cedarburg.
I think we have to, Members Kefri, we have to look at it in context of why all of this was discussed in the first place, when we dealt with the right, the whole issue of the right to refuse to work. And remember we had that whole issue about this person who is going to ask somebody on the job, this safety and health representative, to cease work, what type of training, what kind of, that was the basis of the discussion with respect to the mandatory training. I don't know, from what I'm remembering, I don't think that we somewhat amending 85, aren't we? The whole issue of the right to cease work, 84 and 85. So I think we have to examine it in the context of the changes that we're making to 84 and 85. Maybe we won't even need to speak about mandatory training. I just can't remember how we had determined we would deal with 84 and 85. So it's not to be looked at by itself, but in relation to these persons having the right to say to persons on the job, you may cease work because of some infringement or some danger, and you wanted to ensure that these persons were adequately trained and weren't going to carry out their duties in an arbitrary manner.
Chairman.
Yes, Member.
Member Skeffer raised the issue of clause 84 that Mrs. Celia Brown has spoken to. And we saw just this week in action, clause 84 being applied in Montego Bay. I mean, without the bill. And is it, we have the view that if people like those who are not formally trained, they would have been in violation and not protected for walking off the job because of the unsafe building. In other words, without training, you are condemned to operate in an unsafe environment. The workers in the tax office in Mobile told us they're not supporting that. Is that where you're going to say a situation like that could not be condoned because nobody there had the formal training?
No, that is not where we are going. And just to bring you back to the chapeau 72.1, it is upon request, You say the person conducting a business or undertaking shall, if requested by the safety and representative. So what we are saying is that if they request it, we want them to make it mandatory. We want to make it mandatory for them, for the PCBU to let them attend this training, the prescribed training. So it's not every training that the safety and health representative may come and request, but at least it's prescribed.
That's a point, Order. Clarify for me. The mandatory provision is for who? The trainee or the PBCU? For who?
It is for the PCBU upon the request of the safety and health representative.
But that wasn't the initial understanding. So what you are saying, let me get it clear. What you are saying, if it is requested that the SHR requires trainer wants to attend the course, the PBCU is mandated to ensure that you give them time off.
Not so that course, the prescribed one.
Prescribed course. Yeah.
Right.
So they're going to a prescribed course.
Yes.
Relating to safety and health.
Yes.
And they request it of the PBCU.
Yes.
It's mandatory that they must allow the workers
to attend that.
But it's not that it must be mandatory that the worker attends.
No.
Well, that wasn't the initial. But it's not clear here because MSL is still of the view that at least the prescribed course should be mandatory. But mandatory for whom? So it's not clear here. There are two different things. I can't understand what is in 72.1. That the PBCU must allow the worker or the rep to participate. But 72.1 is giving a different interpretation from what you have here on the document here.
It is because of how the decision was written. To say members suggested that training course should not be mandatory, so we wanted
we're talking
to
on behalf of SHR.
For the safety and health representative. Remember that this was submitted. Remember that this was submitted to us, and we are commenting on the decisions. So in terms of the language of the decision, we have not written that.
Just clarify for me. On page 9 of the document here with the submission, just state specifically, members suggested that the training course should not be mandatory. And in my understanding, members can clarify, mandatory for the SHR, and they can support. And you are saying in your response, the ministry still have the view that at least a prescribed course at 721B should be mandatory.
Yes.
So the course should be mandatory, but somebody must take up the course offer.
Well,
so who should be mandatory for?
So as we said, how it is written in the decision, it is broad. It says it suggested that the training course should not be mandatory. So that's broad, whether it's prescribed or other courses that are not prescribed. So what we are responding to say is that we are of the view that rather than having it broad for every training, at least the prescribed training that is requested by the safety and health representative, that one should be mandatory.
Chairman.
Yes.
Let me see if I can understand what is being said. One, if the SHR requests a prescribed course, the PBCU must allow that.
Correct.
Good. Secondly, having requested a course, the SHR does not attend the course, there's nothing befalls the SHR. Not having requested it, nothing befalls the SHR.
Mrs. Bennett Campbell, do you have a comment?
Mr. Chair,
Yes.
whilst we wait, I'm just hoping that the context in which we're pursuing is we have an idea as to what the end result is that we want.
Yes.
You know, and I think if we have clarity with that, in terms of whether it is a minimum requirement, a minimum awareness by the SHR and such, and then work backwards as to how to arrive at that. So I think maybe...
Yes, and I share your point, Member Longmore. If you look at the functions under Clause 68, you recognize that the SHR will have enormous responsibilities. So, yes, which may require training. So, I believe that is where the ministry is coming.
No, I was just kind of tacking on to that in terms of we're speaking in terms of consequences if this is not being adhered to. But I think it should be from the outset if someone is putting themselves up to be considered. Yes. It should be made clear that this is a requirement of said position. Then you can't be elected. You can't be selected for that position. And if you don't, you are no longer that person because that's what I said. Think about the end result. No, you're not going to fire them from their job. Right.
I'm not saying
the same persons who elect who would be his co-workers would also remove him or her. Yes. I think because remember, no, we have to let the workers recognize that this is their voice and this person is representing them. So if the person is not meeting the minimum requirements.
Yeah. Mrs. Bennett Campbell.
Minister, it seems like we need to discuss this matter a little further. Because what we want, I know what we want to achieve is that for you to be able to effectively carry out your functions as SHR, there's just some minimum level of understanding of occupational safety and health that you must have, some minimum training that must be there for you to be able to effectively carry out your functions. The SHR, we did not change the fact that the SHR can direct the cessation of unsafe work. So what we had in mind is just some minimum training that you must have to be able to fulfill your functions. So that is what we were trying to achieve.
Okay, very well. But these discussions, though, it would not impact 72(1)B. Yes.
Again, so we're fleshing out a piece of legislation, but we must always take into consideration post passage of the legislation, the administrative part of it, and what are going to be some of the requirements. And whilst this is really something for the ministry to work out in its mind, and us as members would want to have that level of understanding. But it's certainly not going to hold up the clause.
Yes.
I don't think we need to say more than we've said in paragraph B, because it is clear that regulations are going to flesh out the details of this course and who's entitled to attend. And so I think we can move on, Chair. And
I agree with you, Mrs. Seeley Brown. I
Yes.
agree with you 100%. But sometimes, you see, for those of us who have to approve the passage of these legislations, we never normally see the regulations. And so it is when the regulation comes, one have to determine whether or not the regulation is aligned to the particular clause as to how we have discussed it and how we how we're made to understand what was the intention then.
Mr. Chair, I know we've agreed to move on, but I believe the whole idea of whether or not it should be mandatory for the safety and health rep, and this is for the ministry's further internal discussion, was actually based against the background of what Member Gale raised initially about whether or not some of the workers were able to matriculate into actually completing these courses successfully, and if not, whether or not they should remain the safety and health rep. So you have to bear in mind sections 85(6), where there's some responsibilities that safety and health rep cannot do unless they have successfully completed the training. And I think that was where it came from.
Yes.
Right. I think for 94,
yes,
my recollection is that that section may now be deleted, so it's really just focusing on 85(6).
Yes, the discussions are. We're now remembering the discussions. Yes.
Chairman, as we move, as we move on, I think 72 2B is also pertinent in discussions that should be had by the ministry. That essentially calls on the PCBU to pay the cost of the course. And I'm not sure whether there's a cap or any control on the costs of our course. So Kawan's bicycle shop has to bear the cost of the course. Doesn't say reasonable cost or anything like that. And so I'm wondering, do we need that? Secondly, is there a role for the state in subsidizing these courses? Because the state is now going to require, and quite properly, small business, medium, large business to engage in this training. And we're saying, whatever the cost, you pay it. I don't know if there's the policies the state will subsidize or so. Some that I'd like to get, because we may put undue pressure on the employers and yeah, because once it is requested, and then connect to that the earlier point that I may request it, you have to pay for it, but I don't have to do the course. And is there well, yes. I can't give direction, but that. So it needs some fine tuning.
Mrs. Seeley Brown, let us. Yes.
Because of how wide this bill casts very wide net and a lot of PBCUs, I'm thinking, Chair, we may have to delete it here. And when we come to the training courses in the regulations, we can flesh it out there as to how you determine how the fees are paid. I don't think we need to put this, have this blanket clause to apply to every single PCBU.
So you're saying that the regulations could make the provision?
Yes, given
in respect of who should.
Given how we have defined a person conducting a business. It can be any, yes.
Very well. Yes. Yes, members, Kefri, other comments?
So
yes.
On a different point, Mr. Simmons make a linkage to 85.6 with 72 in terms of a training, and that the SHR will not be able to give direction if they have not completed the course and so on. And I'm just trying to think, I don't know how regulation will treat with that. But if I elect John Brown as my SHR, then John Brown is not able to initiate the training course or complete the training in line with what Senator Gale has said about matriculation. Then can't give direction, but you would have elected the person before. So is it that you will have some diagnostic tests and safety prior to election? So some preconditions and how you administer. It's clear, because if you say to the workers, you have the right to elect your SHR, then you're saying no, after you elect your SHR, you have to do this prescribed course, and if you are not certified, so you have not met the minimum requirement, because there must be, and you can't give directions. So I think we have to flesh it out some more, probably that regulations, but it can be that everybody would be eligible to be elected then, because some people might just not be able to be matriculated, because we understand the nature of our workplace and the different competency level of individuals. But if you say everybody can be a nominee, hence be elected, then I elect my person, then after the election, you have some conditionalities now to this person carrying out the function, then that could be seen as being discriminatory after the facts. Right? So is it that in every workplace, the number of all employees who so want to be elected would have to undergo a pre-course or a pre-test to determine your competence before you are elected, unless it makes no sense of an election, then you're going to have a system of recall? Is it that?
Minister?
Just to ask, to think back when we had this discussion at previous sittings, we had mentioned the fact that once this legislation becomes enacted, we would not want a situation where persons are not allowed to function because of training. They were not trained. And I remember the example you had raised, Member Skeffrey, about even someone coming into a factory and they see that chemical is spilling and that they can't give a direction. So we had considered that and said that we don't want a regime that is going to be hinged on the training to say that these persons cannot be elected and they cannot function as safety and health representatives. So what we are saying is really that you may also have persons who have had some training and have some prior knowledge. They can function as safety and health representatives. But for the ones who were elected by the workers, give them the opportunity under this legislation that for the prescribed courses, that they will be able to ask their PCBU for them to attend these prescribed courses so that they can get the awareness and knowledge necessary for them to function more effectively in carrying out their functions as safety and health representatives. Because at ground zero, which is really before this bill becomes enacted, we won't necessarily have all of the persons who could potentially be safety and health representatives trained, because that is the reality.
Yes.
So, Chair, we're therefore going to treat with 85.6 in that regard, based on what the ministry has just indicated. I can't remember how we said we would have dealt with 85.6. I know I have it square bracketed, but I'm not.
Well, I'm just checking the clerk's note. I think what the note is saying is that the general discussions then are very similar to what they are now, where persons were saying that the 85.6 would be too onerous. If it is that we are saying that it is mandatory for the SHR to go through that course of training. Yes. But ministry, you have heard the committee again. What is it that you intend to do?
The ministry was to revert to the committee.
We did not look at it in that light because we had, when I said that light, I mean for 85, because we had not gotten the decisions as yet from the committee.
So in respect of 85.6, the understanding is that the ministry will come back to the committee on the way forward in respect of 85.6.
Yes.
All right, very well. In respect of 72, I think Member Brown raised a point about 72.2b. In respect of the payment of fees, and Mrs. Seeley Brown is indicating that we perhaps need to remove this provision here and incorporate it as part of the regulations.
Incorporate what, though?
Yeah, so I was searching. I mean, the matter of the fees and who will pay the fees, or whether the ministry will offer the course, you know, those are the. But as it now stands, the committee is really saying that, you know, whether it is here or in the regulations, there's an issue with 72.2b. But what I will seek, and this is what I really want you to comment on, is the removal of clause 72.2b from here, and we seek to incorporate a clause dealing with fees in the regulation.
We have no objection to that, Minister. We will be guided by the OCPC, Office of the Chief Parliamentary Counsel.
So what is before us then, members, is they take out, yes, we're taking out 72.2b from here, and a clause be incorporated in the regulations dealing with fees and who is to pay those fees.
I hear about taking it out from the bill, but I don't think that will change the concern from Senator Brown.
Yes.
All we are doing is transferring from this bill to the regulation. But
yes.
At the committee, as Senator Gale said, sometimes you don't say regulation 3, 4, 5 years, but you want to still to the regulation comes in.
Yes.
But the broad framework as to who should pay or a cap is a greater concern.
Yes,
in the light that you have different variation in enterprises.
But Member Skeffrey, I think what is being said by the ministry is that having regards to the concern as highlighted by Member Brown, the ministry will have to look back at the clause.
No, I'm not disputing looking back.
And the decision of the ministry will be reflected in the regulations. Is it that you're saying that the decision of the ministry on this matter must come before the committee at this time?
The unfortunate in the regulation will necessarily come to a committee, so that's the unfortunate thing.
Yes.
It just goes straight to both
But the
houses.
concerns have been duly noted.
And sometimes the rigor testing we have in the committee might not take place in both houses.
Yes, but yes, Member Brown.
Chairman, when it comes to PPE, personal protective equipment, we make it clear that's not a burden to be suffered by the employee, by the worker. That has to be met by the person conducting business. Shouldn't we make it clear also that the training shouldn't be a burden to the worker? No, as to whether it is the PCBU who should take it up, or the state, or some partnership, but that's not a burden that should come to the safety and health representative. And that is something I believe we can state, because that's where we want to go.
Yes, but I think, Member Brown, the clause as is already worded is saying that that is not a burden that could be affixed to the worker or the safety and health representative. I think the concern that you are raising now is that to say to, and having regards to the fact that this bill will now apply to all branches of economic activity, you are saying that to impose this, the cost of the training course without capping it on a PCBU may be burdensome, and you're saying some consideration ought to be given to a shared arrangement, or whether the state will absorb these charges.
No,
yes.
Not until. Where I'm going is
yes.
The worker who is the safety and health rep should not be called upon to fund the costs of the course. As to whether, as the bill is now, it says the person conducting business must fund it. And I'm waving a flag, whatever color, for small business people who may not be able to afford the costs of such training, and to say maybe the government should do some of this training and at no expense to the employer. But certainly, in nothing we say or do, whether we put in regulation or so, should leave any doubt that it should not be the safety and health rep, the worker, who pays for this course. And that's what I want to be protected. Because here's the problem now, Chairman. If we don't say that, some smart lawyer will say it's open and it should be paid. And you know what I'm talking about, SG. You don't know who. All right, come on, and I know who we're talking here. Because there's a matter which going to come up that affect your department. Right. So we are concerned that if it doesn't say so, then others may conclude that it was the intention of the Parliament that the worker should fit it. Since the worker is the one who is demanding it, I want to make it abundantly clear that if the worker demands a course which we say they should do, then it's not the worker who must pay for it. That's where I'm going.
So, Member Brown, before you come in, Member Gill, because you're saying that the inclusion of a provision relating to fees in the regulations, notwithstanding that, you'd want in the main text something to say that the safety and health representative ought not to be called on to foot the fees for the training course.
That's correct. That's correct.
Mr. Chair, right now you have some employees who have to foot the bill. Employees who have to foot the bill of providing their own protective equipment. And that is how some employers treat this situation. So we're prescribing now with this piece of legislation an encouraged change in behavior. So, you now have a situation where the ministry is saying, under support, that training must take place. Training must take place. But you will have some employers who will suggest to a worker, but now you want to become safety and health rep? You are the one who your workers and your trade union elect as safety and health rep. Now this training, because I don't know what those fees will look like, but this training is not a part of my budget. I never planned for it. So you may have to hug it up. And so we have to be very clear in our minds how we treat this thing that calls on something that is mandatory, but where the employer will suggest that I cannot afford it as part of my overall financial obligation. So, Chair, these are nuances in the bill that we have to find a way to work it out.
What if we ask that both parties pay jointly?
Yes, using my member, Calvin.
It's a benefit to both parties. On the one hand, because if we're looking at the common law position, if you go into a workplace and you see a dangerous situation, and notwithstanding you're seeing it and you go on, you volunteer to do whatever, then you'll be treated as volunteer. So in those circumstances, you're asked to take care of your own safety. All right. So you elect to pay 10 cents of the 20 cents that is charged for the fee, and equally, both parties will benefit. And I don't think there's equity in taking.
Yes, member.
I just like to disagree with my colleague Campbell. We could use the same principle as I said to the personal protective unit, to the helmet, to the boots, and all of those things. Because we could say it's mutually beneficial to all. It operates in a different environment. And we recognize for the good of the society that those who are being paid 7,000 plus per week shouldn't be paying for a course.
That would benefit the employer.
Right? And so that what the, no, that's also you go down to some of them shop and selling chemical and all of them things there. People pumping gas. So it's 70% of the workers in the country are at or around minimum wage. Let us bear that in mind. So, Chairman, I want it to be clear that these courses are good and they should be taken up, but it can't be for the workers to pay. Right now, I know if JPS or Bauxite is putting on a safety training, they are not going to ask the workers to be contributing. I don't see why Lammy's party shop should be required.
Campbell's an associate.
Right, to do that. So that the state because we are the ones pushing this, need to cover these people. And to the extent that we can. And certainly the private sector at the larger end will do this because it's important to them. I mean, I just want to make it clear. We see one company, remember Campbell, because of a safety breach, had to shut down because of a lawsuit, $600 million lawsuit. So it's in their interest to avoid that by funding it, but you can't impose more costs on the smaller businesses or business in general. So again, I ask the question, protect the worker, I say this, protect the worker from having to pay, but is there room for a partnership with the state? Because the state also benefit from having to go pay out disability insurance and all of those things. So it's a win-win we're talking about, but don't make the worker lose. Because if that worker must pay for a course, which means that the rent is reduced this month. That worker not went up that course and would have defeated the purpose of encouraging people to go to the training.
Mrs. Seeley Brown, yes, I invite you to having regards to what Member Brown had said earlier, not his most recent comment. The recommendation that you put forward is being accepted in terms of moving this provision into the regulations, but notwithstanding, Member Brown is suggesting that we may need to, on the face of the bill, says that the workers or the safety and health representative shall not be responsible for paying the costs or the fees associated with the training course. Yes.
I remember earlier in the bill we had a provision which provided for them not paying for safety gear, so we can have put it link both provisions and have a clause that deals with both what Member Brown is suggesting and the whole issue of not being able to pay for safety gear, so have it in one part. Yeah.
Well. Yes.
Chairman, just a comment on moving the provision in the bill to the regulations. You'll have to amend the clause 213, which is a regulation making power, because 213 3G now speaks of prescribing fees, but it's not those types of fees. So before you can put something in the regs, the Act has to empower it.
Very well. Duly noted. So, Mr. Mahan?
I'm not for, are we agreeing that the PPP model would be in the Act and not in the regulations?
Personal protective equipment, PPE. Yes. She has agreed to you, ma'am. Yes.
We're leaving that in the Act, and I'm saying that that's the same provision. We can then put whatever you're requesting of having them not pay for their training, we can also link it to that clause. So move it from clause 72 and link it to that clause also.
Very well. You may proceed, Mr. Mama.
So we're at the decisions, point 3, 72, subclause 3 to be deleted. We did not comment on that. Point 4, 72, clause 6 to be redrafted. We did not comment on that. These are decisions that were made already by the committee. So for 72.6, I'm not sure if OCPC, Office of the Chief Parliamentary Counsel, would want to speak about that. 72.6 to be redrafted.
Are you able to say, Mr. Mahan, what the concern of the committee was at the time? Yes, I think so too. Yes.
Outside of that, 72, 2B, sorry, no.
Question, Chair.
Yes.
What's the difference between 72.6 and 72.2B?
Yes.
Same thing.
Yes, that's why I asked Mr. Mahan if there's any clarity.
I just want to bring you back to page 8 of the same document. Clause 70.5, and we had discussed at the previous sitting about redrafting to provide payment of OSH workers on weekends. Otherwise, the entitled was subject to interpretation. That's point 5 on the clause 70 on page 8. And the response was in regards to what are the considerations as it relates to performing his or her functions, attending any training as required by clause 72, he or she is entitled to receive payment at regular, single time or premium time, and a half or double time rates, having regard to any applicable legislation, contract of employment, or collective agreement. So based on what the deliberations are, then we would have to also revert in relation to this clause. I'm asking.
Yeah, we are at 72.6 or 72.4?
So in terms of the link.
Yes. Could you just make a connection for us, please? Yes, because I think what is before us is that Mrs. Celia Brown is saying that by virtue of the discussions just now, do we still need 72.6?
Minister, we need the actual minutes because what I have here is review redraft to meet 72B. So there was something about an overlap between 72.6 and 72B that would have come up before in previous discussions, but I don't have the actual. So that's my notes in relation to the Joint Select Committee.
Yes, and with 72.2B and 72.6, yes, there seems to be a connection, but I think the committee has now taken a position that 72.2B will be moved to the regulations. And by virtue of that, and I think that is what we are seeking a comment from the ministry on, is whether or not 72.26 is still needed in the bill. Please.
It's needed in another place, as we had discussed, Chair, where we're going to deal with the protective gear, to say that they're not to incur any cost of protective gear. This will be a subclause to that provision earlier in the bill. So we put it one place and delete it from where it is here.
Yes, Ministry, I've heard that.
Yes, Minister. This part was speaking about attendance of a course, so it is kind of repeating 72B. In relation to PPE and the payment of that was somewhere in clause 13. I will. What was there, I think, was the subsection 13.4, where they have the whole thing about levying the charge, and basically the subsection 4 applies whether or not the PCBU pays the work an allowance or extra salary or wages instead of providing personal clothing or equipment. 4 was saying that the PCBU should provide protective clothing or equipment.
I think, Mrs. Bennett Campbell, the question of whether we are discussing 72.6 or 72.4, I think is what we need to determine now, because I believe the comments that OCPC has made is squarely in relation to 72.6, and what is put forward and recommended by them is that the provisions that deals with personal protective gear, you could have a subclause that deals with courses and the costs associated and who should pay, and the fact that the SHR ought not to pay the charges associated with the training. So I think what is being put forward by the OCPC is the relevance of clause 72.6 here, having regards to the earlier decision that the committee made.
And that's what I was pointing out, is that it was said from before that the two were being repeated.
Yes.
So that's why the redraft was about merging or taking out one, but I don't have the official minutes. I'm just going from my notes. So I was not opposing what was being said in relation to 72.6, because it was recognized that there was some amount of repetition.
Okay, very well. Yes.
Yes, but to go further, because there's an impact to 72.7, because 72.7 is the offense that was linked to 72.6. So whatever you are going to do to 72.6, you have to take into account that offense. And Mr. Basco was saying if we were going to move the provision to the part that deals with duties and all of that, it's already an offense there. But I really want the committee to reconsider the type of penalty that will be applied for this type of matter. I don't know that a criminal sanction is really the appropriate sort of penalty. I'm not saying you can't have a sanction, but a criminal offense, I think, is something that you should really reconsider. And I'm not, because there are other things that you can do to make the employer recognize. Yes, you must allow persons to attend a course. Yes, you must pay for it. But to say that you're going to carry the employer to court and charge them is another matter, and perhaps that could be reconsidered.
Chairman, I thought.
Yes, Member Brown.
72.7 had died because I recall attending the funeral for the criminal punishment in the bill. So I'm with the Solgen, but I thought the funeral had already taken place. But it will appear to me that the body is still warm, and I think we need to bury any thought of criminal action right now.
All right, Minister.
I'm wondering if we would leave 73 in the bill, clause 73, Chair. Should we leave 73 in the bill? Obligations of PBCUs, multiple, should be deleted.
The decision was taken on that already, yes. 72, 6, and 7, that's what we're dealing with. Members, do we agree on 72, 6? Yes. Agree. And yes. And to be incorporated in. No, where we're going to put the PP.
There's no number yet, but I would just.
Yes, make a note, yes, please. Ministry, in respect of 72, 73, 72, 7, do we have a comment based on the discussions that flowed earlier?
We know the discussions, and as before, we are cognizant of the fact that we need to look at the whole penalties system that is in the bill. So we will be looking at that and revert.
Okay, very well.
Just to look at the folly of this. The third schedule require up to $70,000 fine, up to $50,000 fine. What could be a likely cost of a course like this? Probably 100,000, 200,000. I don't know, 250,000, and then somebody goes to court. No, somebody goes to court and get a fine of $2,000. It suits me to go to court over and over. No. It suits me to go to court over and over, right? Because no, man, but it don't matter. I only going to pay 2,000. It depends. I only going to pay 2,000 or 5,000, or even if you maximum 50,000. It's a saving for me, depending on the cost of the course. There's no incentive here to pay the cost of the course. That's why I asked what would be the likely cost of a prescribed course.
Mr. Mohan, I see you have a .5 here, the merger of 74. I think that is what Mrs. Bennett Campbell was commenting on. 74 and 72, 4. Mm-hmm. Could you just take us through this?
So when I was discussing before about trying to establish a link with 72 and 70 subclass 4, it was in relation to the time off. Because if we are going ahead with having the safety and health representative attending this course, then there must be something that speaks to any entitlement that the safety and health representative would have going to this course. So I had pointed you prior to page 8, which was really speaking about what we had discussed in relation to training and the safety and health representative going off on training, whether it is during the normal working time where you would get the regular rate or the premium time and half rate. So if we're going to be looking at merging, and if we're based on the recommendation of probably moving these to regulations, if it would be required to have it here on the face, or would we need to consider having that in the regulations?
Cecilia Brown? Yes.
I think it is serious enough to leave it here.
Okay.
So when you mention about the prescribed course generally, I think it's serious enough that you may want to leave it in the legislation, Chair.
Very well. Member Brown, you?
Keep it there.
Very well. So we agree to that, members?
It appears, Mr. Chairman.
Very well. What do you say? Okay. Ministry, you may proceed now.
So since we are at 72,
I think we have completed 72.
Well, we were just trying to answer a request that was made of us in relation to the mechanism for the approval of the training course. So.
Okay, fine. Well, proceed.
Right. So a predetermined curriculum would be established with the assistance of the Technical Advisory Committee as set out in 136. That's the Technical Advisory Committee. The curriculum will, among other things, have a requirement for information on the fundamentals of recognizing and controlling hazards and the main features of the OSH Act and its regulations. This curriculum would be made publicly available. Institutions that are interested in delivery of the training would submit an application with other supporting documents to the director, who will submit same to the Technical Advisory Committee for review. Any approval of the training courses offered by the training institutions by the director will be consequent on a recommendation for approval submitted by the Technical Advisory Committee to the director. The approval procedure will be set out in regulations. So some of the deliberations in regards to cost and all of that, those will be some of the elements that perhaps will be considered in determining which institutions will be approved for granting the training courses to be offering as trainers for the training courses.
Yes, it is. I believe that the members would have requested this kind of information. Members, any comment?
Go on. Check. I see where you're going. Are you going to the modules, for example? Do I have to go through all the courses? I mean, it says courses. Are there different levels of courses? Are there courses that are going to be specialized? For example, people in the chemical sector, people into construction. Is there thinking and a philosophy behind the courses?
Yes, there's a thinking and philosophy surrounding the courses. We are thinking that these short courses, and if you look at Canada, because Canada has something similar, they have 3-day courses for certification in different sectors. So you have agriculture sector, you have all sectors, you have manufacturing sectors, you have offices, you have service sector, where you have sectors that deal with, like for example, highly hazardous material. Then we would have to be looking at the persons who would require to attain a level of qualification that may not require them necessarily to undertake these courses. But for the very basic, in terms of what we wanted to achieve, having the safety and health representatives being exposed to material that will allow them to understand the concepts, the basics of occupational safety and health, and how the legislation relates to them in carrying out their functions in the workplace. We have to view that having these short, probably 3-day courses will be sufficient. We have seen similar models used in America, OSHA, where they have, instead of days, they use hours. They have the hours that the 10 hour, the 30 hour that allows persons to be sensitized around safety and health in the workplace. Outside of those courses, you have other higher level courses that persons can matriculate into, and that is based on their own personal development. So if you want to do advanced courses in safety and health, then it is at the liberty of that person to do so.
The course that the health and safety worker may choose to do, as we were discussing earlier, would that be any in general or any specific of the courses that may be offered?
We're looking at it specific because, for example, if you have a worker who's in an office, the hazards in an office will be different from the manufacturing. So you have to ensure that the training is somewhat aligned to the environment in which they would be working.
From the experience of Canada, US, how many different courses we're looking at here for JA?
Well, we have been looking at it now at the surface, probably around 4 or 5 courses. As I said before, we're looking at on a sector-specific basis for the courses and see how that operates. Then if there's additional courses that need to come on stream, then we can make the adjustment accordingly. But we have to consult with the stakeholders to ensure that what is being offered, and that is why we have the technical advisory committee playing a role in determining which courses will be sufficient to the different sectors that exist.
So if it's going to be sector related, I can see the alumina sector even being different from the bauxite sector. I can see the construction sector, I can see agriculture, I can see manufacturing, and manufacturing can be broad. But you're saying 4? That 4 courses? They clearly want us to be general about the legislation itself.
That the legislation would be a component and the curriculum for these, But you spoke about bauxite, alumina, manufacturing. That course could consume both of those sectors, manufacturing, bauxite and alumina, because they're manufacturing. So instead of having it seem unwieldy when you're having so many different sectors, we'll be looking at seeing where there are similarities. Because the fact that how we operate even on the factories, like where we see industrial establishments, when you're industrial, you can see where factories, construction, shipping, dock operations fall within that type of industrial type activity. So that is the intent of how we plan to set out the different modules for the training.
Member Skipper?
Mr. Chair, there's some clarification here. You say a predetermined curriculum. So is that predetermined, meaning one? So will that cover all workers in the society and all SHRs, who will be engaged on behalf of the workers? Will they be, if they select to do the course, is this a common curriculum for all, whether you're in the bauxite industry, the sugar industry, you're the carpenter, the barber shop, whoever? So is there a common curriculum where all workers will be exposed? Because you say a predetermined. And who will determine that curriculum? Because you said at the starting boat, established with the assistance of a technical advisory committee. So will you have a separate body developing that curriculum, working with the advisory committee?
Well, in terms of the courses will have some general criteria. For example, inspecting workplace, you can see where that happens in manufacturing, in offices, identifying hazards, investigating accidents, and making recommendations. So how to recognize, how to control and evaluate hazards. There's a standard approach to that process in terms of even control. We have mentioned about personal protective equipment, that's one level of control. You have engineering controls, you have administrative controls. So depending on the type of sector, whether it's manufacturing, whether it's office, whether it's service sector, you want to ensure that the delivery of this curriculum is somewhat put in the context of this.
I follow. So the curriculum developers, will they be exclusive members from the ministry, or would it be a team or a task force?
Well, we'll have a team, as we said, but the ultimate scrutiny of it will be the technical advisory committee,
within the
which will have members. You have employers, you have persons from unions, you have persons from the academia, you have other technical experts who would form this committee.
Okay, and as next one was for the approval of the institutions that would have interest in delivering the course. Is there will the regulations speak to a clear set of guidelines to approve these institutions?
Yes, and that is why we say that the approval procedure will be set out in regulations.
Okay, and the duration of the course, is it specific or fluctuating?
So we are looking at 3 days. I mean, that is still subject to change because, as I said before, we still have to have the involvement of this constituted technical advisory committee, as well as we have to engage the different stakeholders as to what is the best time to achieve the elements of the curriculum.
And finally for me, in terms of matriculation, will it be a formal assessment?
There will be an assessment at the course. One of the things that we want to ensure is that how the course is delivered, it will be in a manner that persons can understand. So despite the educational attainment of the participants, we will be looking at how the course is delivered. For example, is it text-based? Is it practical? Would we have pictographs so persons can look at pictures and they can identify hazards? And this is a model that we have seen working. The ILO has a database which assists persons in looking at pictures to see where hazards exist in the workplace and what are the mechanisms that can be, the control mechanisms that can be put in place. So it doesn't necessarily have to be something that requires a lot of reading, but it is how the material is delivered. And these are things that will be considered in the assessment and approval of the institutions that will be delivering this course.
Finally, for me, in terms of the previous discussion we had about the payment of the fees, would the ministry probably explore the idea now, since a 3-day course, a relatively small period, partner with, for example, HEART NTA, which is a government agency, does training fairly well, and partner with NTA to be the main deliverer of this particular course? Can be done on weekends.
Well, in terms of the partnership and the delivery of the training course by the ministry, well, we have been considering the fact that there's a nationwide network that exists, and we're thinking of using that platform. Heart Trust is one of the institutions that has, if you want to say, schools or outlets, campuses in different sections of the island. So it would be, it has been a consideration to engage them when we reach that point as to the delivery of the course throughout the country. Persons don't have to be traveling from Westmoreland to Kingston.
Yes, yes, Member Gill.
Back to the question of assessment. Now, Mr. Mahon, I'm an employer and I pay the fee for the employee to attend such a course. Is there going to be a requirement that you provide a report on the assessment, on your assessment of the employee attending the course back to the employer?
Well, we want to ensure as well in terms of how this course is delivered and the relationship between the PCBU and the safety and health representative is one that will still be guided by any procedure. If you have a HR manual or procedure in terms of how training is generally dealt with within the workplace, we are of the view that once those are agreed and established procedures, that those should be the mechanisms by which, whether it is a report that the employer requires based on the agreed procedure as it relates to employees or workers attending courses.
And so again, coming back to the assessment, if that report suggests that the safety and health representative may not have matriculated, and so the employer or person conducting business might say, well, you're not qualified, and so you can't say nothing to me. I'm just pointing out these scenarios where you establish on the one hand a requirement that needs to be fulfilled, that you are anticipating must be fulfilled, but it also creates on the other hand another type of expectation. And if that expectation is not materialized, what may be the outcome?
Well, we thought about that, as I said, but it is in principle it is similar to an employer outside of occupational safety and health having a request from a worker to attend a course which will be beneficial to the organization, and there are established policies in some organizations already that touch on concern how that attendance and completion of that course, is set out. And we didn't want to have that prescribed in a regulation because that is an administrative thing that probably obtains because of the contractual arrangements or any agreed. As a union person, you could appreciate the collective bargaining process and what has been agreed.
I'm not prescribing to you that it must be a requirement in the legislation. I'm not prescribing that. I'm just suggesting a what if situation. Because I know some employers will say to the worker, but you never matriculate. And so, how would that worker be viewed? I don't know the extent of your assessment or your training program, that resides over by the ministry. But I'm just trying to wrap my head around these possible events. If and when they occur, how can they be treated? Because they will.
Well, as you would appreciate, the safety and health representative is not elected by the PCBU. We all know that. And it is the worker. And we are also cognizant of the fact that training is really upon the request of the safety and health representative. So training should not be used as a means to say that the worker, who is duly elected by as the safety and health representative, cannot perform or is not qualified to perform as a safety and health representative in the workplace because he did not even request to attend this course, because this person is duly elected by the workers in the workplace.
Mr. Chair,
yes,
I've heard, but there's still some gray area in that. And that's why I said earlier, there has to be some prerequisite for the selection of the SHR, because a person requests the course, went to the course, did not matriculate, but then the person still, the employer might say, as Senator Gill is saying, then this person is not the best fit in my organization, though the person was elected by the workers. But then every employer will want to ensure that I have the most competent person. As SHR, this person requested training, I provide the resources by law, but this person has not met the minimum competency. So I think we have to flesh that out somewhere, and then to say we can't do anything because we didn't elect the person. That is true, but that set up a divide between the employer. Because no employer thinking in, not an employer myself, but thinking in that context. No employer would want to be comfortable knowing that I have a person as a safety and health representative that did not meet the basic requirement of a course. So I think that remains a gray area in my mind. I don't have the answer, but it's something we have to ensure we sort out for cohesiveness, because the workers want to be happy that they have the person so minimum competency, likewise the employer. Because at the end of the day, the objective is to ensure that this person can carry out the task in the best interest of the organization and all stakeholders.
Point duly made, Member Skeffrey. I don't know, Mr. Mahan, is there any final comment before we move on to?
The concern raised by Member Skeffrey is noted, and we will look and see how best to address that.
Okay. Members, we now move to the second sheet that has been provided by the ministry, the one that came this morning, dealing with clauses 80 to 82.
Just confirming that
yes.
on clause 74, they're saying, the ministry saying they'll revert. On the back, if you look at page 10 of the document we're just using, just to put that to bed is what I'm...
Yes, I'm with you, Member Brown. Oh, I think it is in keeping with the general discussion that you raised earlier. So that's why I have overlooked it at this stage. Yes.
No, just for the, I just wanted to...
Very well. Very well, yes. So we proceed, Minister.
Yes, good afternoon. We had a look at clauses 80 to 82 based on our recollection of what we were asked by the committee to do. I recall that we had occupational safety and health matters and we had occupational safety and health issues, and there was some amount of confusion. So what I recall is that we were asked to set out the mechanism we have in mind for the resolution of occupational safety and health issues. So, an occupational safety and health issue, or OSH issue, may arise between the PCBU and the worker in relation to the following. And so what we had done, we had gone back to clause 49, which sets out occupational safety and health matters. Identifying hazards and assessing risks to safety and health arising from work carried out in the workplace. Making decisions about ways to eliminate or minimize those risks. Making decisions about the adequacy of facilities for the welfare of workers. Proposing changes that may affect the safety and health of workers. And making decisions about the procedures for monitoring the safety and health of workers. Well, probably don't need so many workers. Monitoring the safety and health conditions at the workplace and providing safety and health information and training for workers. So what we had explained before is that a matter that is not resolved would have escalated to becoming an issue. So we would have been taking out the whole concept of the matter and just dealing with occupational safety and health issues in the bill.
So is it that you're saying that we are doing away with clause 49 in its entirety?
Yes, because we're trying to merge it into the whole concept of issues instead.
Yeah. So.
But at this point, I was just setting out the policy to them.
Very well. Members, are you following?
So I would like to go over now to 80 in the bill. So 80 had said resolution of OSH issues. In this part, parties in relation to an issue means the following. A, the person conducting the business or undertaking or the person's representative. B, if this involves more than one business or undertaking, I'm going to say P, the person conducting each business or undertaking or that person's representative. C, if the worker or workers affected adversely by the issue are in a work group, the safety and health representative for that work group or his representative. And then we had a D. And remember, we had taken out the concept of the work group. Now, from our recollection, concerns were raised in relation to the role of a trade union in this resolution of OSH issues. And I know that CPC had also raised, not CPC, sorry, I think it was legal reform, from my recollection, that should the party to the issue be the representative? So we look back at that and we separated it. So the parties to an OSH issue means the following. The person conducting the business or undertaking, or B, worker or workers adversely affected by the issue. In the case of workers who are members of a trade union with bargaining rights, that's the collective, the trade union can also be a party to the issue. And why we had that in is that we went back to the whole concept of the collective and that the union standing in the place of the worker in relation to a dispute. So that is why we had put the trade union in as a party to the issue in relation to the worker who is a part of a trade union with bargaining rights. All right. Number 3.
You keep in the brackets collective.
Remember, I am not drafting, so I was just trying to explain to persons who do not know. When I say a trade union with bargaining rights, I'm talking about the whole collective setting as opposed to the non-unionized worker.
I'm drafting and I need to be clear. In relation to 1, when you speak on occupational safety and health issue. In my mind, when we were looking at it, I thought you were dealing with a particular complaint or a type of complaint that may arise. When you speak of it being an issue, I'm not clear as to what is in mischief or what is intended by even paragraph 1. Because I was thinking of this issue being something that arises out of like a complaint. So there's something that would have to trigger this complaint, something that happens at the workplace, and then an investigation is carried out. And so when you speak of it in this manner, I'm not clear as to what exactly you're referring to when you say an issue in relation to identifying hazards, making decisions. I'm really not clear.
So we are coming from the 49. So it was talking about consultation being required in relation to certain safety and health matters. So if you're making decisions about ways to eliminate or minimize risk, and there's some disagreement between the PCB and the workers as to how you eliminate or minimize those risks, the measures you put in place.
49, 48 and 49 falls under Part 5, which deals with consultations and representation and participation. And it's only, to my mind, it's just speaking to circumstances in which when you have a duty in relation to the Act, you must, as far as practicable, consult, cooperate, and coordinate activities. So I'm not seeing the link between what is in Part 5 and how we are taking this now to speak to, yes, to Clause 80 and this whole issue of an OSH issue. Because I'm not understanding.
Mrs. Seeley Brown, when I looked at what is being suggested here, that's exactly where I went. Look at how this could have been aligned to consultation. But when you look at the wordings now in consultation, it is not somehow aligned to this. Now, these are issues that let me put it another way, because these are matters that can be disputes, that can lead to disputes. In 80, yes. But when you look back at 49, in terms of aligning these areas, they don't align.
Because what 49 is saying is that whenever you need to identify hazards or assessing risk or making decisions in relation to risk and hazards and the welfare of workers, a particular type of consultation must take place. I have no problems with that. But it's linking it now with an OSH issue in Clause 80 and saying that this issue may arise. In my mind, I was thinking, Chair, that an issue would arise in relation to a complaint. So when it's done like this, I'm not clear as to...
You might have a situation now where the person conducting business might want to set up a particular construction. And no, there's no consultation now. But because of setting that up, it creates an occupational hazard. And that becomes an issue. There's no consultation. It becomes an issue where the employee now recognizes that we might have a problem if this is done. So that is what creates an issue. It is not out of the consultation that may be taking place that the issue might be identified. So there are two different scenarios that has to be taken into consideration.
Chair, let us look at Clause 81. Mm-hmm. And Clause 81 speaks of how this section applies. And Clause 81 obviously relates to Clause 80, right? And it says this section applies if a matter about occupational safety and health arises at a workplace or from the conduct of a business or undertaking, and the matter is not resolved after discussion between the parties to the issue. So this is now something that has caused some problem, some hazard, right? And you're now seeking to set up a procedure to deal with it. So that is why I don't see why we're linking it with the duty to consult, which is clear in Clause 48 and 49. So do we even need to speak, therefore, of an OSH issue?
Chairman, Sorry.
Yes, Member Brown.
You finished? Yes. Chairman, I read these at 1 and coming on to 2, similar fashion as Mrs. Celia Brown. They are essentially disputes. They are essentially disputes, matters that may be considered by, in the end, the tribunal or whatever, or the Ministry Conciliation Department. So that's why I read this. And maybe because they have not said more, it may leave the drafters a little confused. So if the ministry is confirming that this is, in a sense, a broad identification of the possible dispute heading, then that may make it clearer for them. Mike, yeah.
Thinking maybe the draft was intending to deal with resolution of disputes when a dispute arises in the workplace, and rather than an issue, even though that is the term that was used. I'm thinking that I don't think it relates to clauses 48 or 49 in that regard.
Just in the context, because when 81 speaks about matter about occupational safety and health, it was really trying to speak about the safety and health matters identified in 49. That is what I understand as the intent, is the safety and health matters there, because we actually came and we had said that it's really safety and health matters. It's just the way it was drafted. It was really the safety and health matters. But I will look, but I don't want to use the word dispute because of the whole concept of industrial dispute. So maybe there can be another way to do it. But we definitely don't want the dispute or the confusion with industrial dispute, because remember that industrial disputes also go to the tribunal. But it's really that these are issues that if they are not resolved, they can then escalate to the right to refuse unsafe work in some instances.
So then that would be some sort of occurrence that would have taken place that has not been resolved, right? So that is why I don't see us linking it to 48 or 49, because 49 is just saying when you're going to implement whatever measures as a PCP, a person conducting a business or undertaking at a workplace, certain types of consultation must take place. You understand? And so I don't think we need to conflate this with what we are dealing with in clause 80. How we fix it, as you say, is a different, we have to think about how we're going to fix it. Whether we can't call it a dispute, but I don't think both are related. From reading the draft, I don't think so.
And in fact, a failure to consult would be one such breach as well. And could I agree with what Mr. Celia Brown said, and they need to work it out. It strikes me as dispute, but I understand too the issue of nomenclature. Is it a dispute? Is it a complaint? But let me raise one issue, one practical experience. It's not here, and I'm not sure it would capture it. I'm in a workplace, and the company decides for its own safety arrangement to do tests on my alcohol level or any other drugs. And I want to challenge that policy. Would this be captured here? Let me, since you're chairman, you are familiar with a place called St. Anne's and the hills of St. Anne. When you find a worker says, I didn't smoke, but I ingest I had some tea or some roots, and that's what is showing up in my system. And there's a dispute between the employer and that worker about the testing system, etc. Because it is undermining safety is part of the thing. Would that be captured here, or it will be said that's such a testing and thing isn't covered under the complaints, dispute issues?
would fall within E1 in our view.
Yes.
Because it may have an impact on the safety and health if it's not addressed, and the impact on other workers.
What section are you referring to?
One.
Sorry, but the way it may not impact health and safety would be one other view. At my level of THC isn't impacting health and safety. But it is being argued that it could have an impact. So how do we deal with that unique nature of Jamaicans who don't smoke but who are found to have high level? I'm not going to the JADCO and the WADA levels of testing, but there are some realities in the workplace that I have come upon.
What you have raised, Member Brown, is something that I have even received calls in regards to that. Because what we want is to have that settling a policy between the workers and the employers once there's an established standard of testing. And 1E, the PCB has an obligation in terms of ensuring safety and health throughout the workplace for all. And EI, monitoring the safety and health of workers. Impairment is something that the PCBU has to take into account in terms of workers and a safe system of work. So it is really to ensure that we are formalizing, and I mentioned before about having a management system in place. We have to ensure that the employers, the PCBUs, have these situations assessed that what can be hazardous in the workplace. And you look at an impaired worker. If there's a standard that is established that this is, or above this limit is impairment, and these are the reasonable mechanisms and ways to determine if you are over that impairment. You have seen in law enforcement where they use a breathalyzer. You have seen where they have had the sobriety test where persons walk a particular way to determine if there is impairment. So it is really trying to establish prior to those situations in the workplace what is required, and having these procedures signed off on by both the workers and the PCBU.
Yeah, just through it.
Yes, Member Brown.
Does this therefore capture who set the standards? Is it unilaterally set by the employer? And sometimes often it is the employer's head office somewhere in foreign that is unique. That doesn't take into account the realities of Jamaica. Also, so that's one, the level that is set. That may have become a source of dispute between the local, and also the right not to be assaulted. Do I have to take a test? I have an accident or a near accident, and the company says, well, go to the doctor and do a drug test. Can I dispute that under this legislation as to whether I must go and do the drug test? I just don't know if I've dealt with that, but I can see issues because they have come up in the past, coming back up now, as to does this legislation gives or take away or in any way affect the issue of I must go and give a blood sample.
And that is why we are saying that this whole business of consultation in the workplace is very important. And mention was made of the definition of consultation and having a code of practice that speaks to consultation in the workplace, because you have to have this consultation where you can now have these agreed standards and procedures in the workplace that touch and concern safety and health of workers. So it should not be a surprise that is set out, a decision is made by the PCB and it is pushed on the worker when it impacts the safety and health. Because if you look on the point 1 from A to E, right, what you have mentioned as examples can fit within the constructs of one of these points that are set out in the paper. So the parties may have an issue in terms of the decisions, and that is where the whole other points below will flow, right? We have identified the parties. It could be the person conducting the business undertaking or the workers. And then within the ministry now, there's a mechanism that is set out further down in the other points as to how to treat with resolving these issues.
Yes.
And that is why I think the problem lies in the bill. We don't have a proper procedure or an adequate, it's not spelled out in the bill. What happens where a dispute arises? We know that the tribunal, it can end up at the tribunal after it has not been dealt with internally, but there's nothing which sets out what is the procedure, apart from 81.2 just saying in accordance with the relevant agreed procedure.
I don't know if this document contains.
So that's why I'm thinking, Chair.
Procedure, yes.
Yeah. So this whole issue.
Yes.
Yeah.
Mrs. Benny-Campbell?
The bill did try to set out the mechanism within 82, but that's what I was trying to, because I had come with an amendment before because there were some errors here in how it was approached. So what I was trying to do now, can I get to point 4?
We can't get there yet so are we then determining that what is an occupational safety and health issue is a complaint and not necessarily anything that is linked to consultation? Are we getting to that point before we move on?
Yes, but we will tailor it. We have to tailor it in light of the concerns you have raised. But I don't know if we're using complaint, because we use complaint for the reprisals. So I have to look at the language in terms of how we describe it, what term we're using.
Right.
So the only thing we're getting at is the language and how to
with
set
respect
it
to it being a complaint or a dispute. So this is not in any way linked to 48 or 49?
No, and it was not really intended to be, because I was going to delete 49, but I was just showing where the problem that the JC had, where it emanated from, because we had the matter and the issues. So it was actually trying to show where the problem started from for me to move on.
So then do we even then, if that's what we're saying, can't we then just start at 81 and forget about this whole thing about an OSH issue? Can we then start at 81? It applies if a matter about a matter in relation to occupational safety and health arises at a workplace, and leave out this whole issue.
As why? So that any matter that...
And then, so rather than speak of an occupational health and safety issue, a matter in relation to occupational safety and health arises at a workplace. So you start at 81 and then you take your procedure from 2. And because what you're proposing in 1 doesn't relate, in my view, to where you want to get to in clause 81.
Chairman, it's striking.
Yes, we'll consider it.
Go ahead.
Yes.
Saying we will consider it because we're trying to simplify and not make it more complicated.
Yes. Member Brown.
Which was the point I was going to make. That again, both sides need to just sit down and work it through. I want to suggest, as they work it through, the following. I believe in the Labor Relations and Industrial Dispute Act. The definition of a dispute is an industrial dispute. I was trying to recall industrial dispute. And I see nothing wrong with having a health and safety dispute, because that's what we're talking about here. And so that there are 2 different types of dispute: an industrial dispute, which is defined in the way it is, and an health and safety dispute. So it is clear that what we're talking about is dispute and the resolution of those disputes. That would be an approach which I'd want to recommend when they talk around the issue, that they give consideration. too.
Yes. Minister?
As I say, we will sit down and consider the correct terminology that we want to utilize to cover the concept.
So, proceed. 2.4.
What's everybody looking at? All right, the mechanism that is proposed. Now, we looked at more the treatment of essential services under Section 9. Reason being, we thought that we wanted these issues or disputes or whatever terminology to be resolved quickly so that they don't actually escalate if possible. So the parties to the issue or their representatives are required to resolve I'm going to use issue for the time being, issue in accordance with the agreed procedure or the default procedure prescribed in the regulations. Where the parties have tried but failed to resolve the issue in the manner referred to in 4A above, all or any or all of them or their representatives may report the issue to the minister in writing, requesting assistance in resolving same by means of conciliation. The report should state whether the party making the report knows of any steps which have been taken towards a resolution of the issue, and if so, what are those steps and the outcome. During the period of 10 days, beginning on the day on which he receives the report, that's the report from the parties, the minister is required to give directions to the parties in writing to adhere to such procedure in point 4A above, which is your agreed or default procedure, within a specified period where he is not satisfied that such procedures were followed. If any of the parties to whom the minister gave directions to pursue a resolution of the issue report to him in writing that the procedure was followed without success, the minister is required within 10 days of receiving this report to invite the parties to conciliation meetings, and where conciliation fails, refer the issue to the tribunal for resolution. If he has not received a report at the end of the period specified in directions, the minister is required within 10 days from the date from which the specified period expires to invite the parties to conciliation meetings, and if conciliation fails, refer this issue to the tribunal for resolution. D deals with a situation where the minister is actually satisfied that the mechanism was followed. During the period of 10 days beginning on the day on which the minister receives a report under 4B, that is report of the matter, and upon being satisfied that the procedure was followed, that is your agreed or default procedure and regulation, the minister is to invite the parties to conciliation meetings, and where conciliation fails, refer the issue to the tribunal.
Yes, Member Gill.
In that paragraph below C, the one that issues, if conciliation fails, refer the issue to the tribunal for resolution. I want to go above that, where that last sentence, if he has not received any report at the end of any period specified in those directions, the minister is required within 10 days from the date from which the specified period expires to invite the parties to conciliation meetings. So you give me an invitation, but I don't have to come. I don't attend. How is that treated? Because you can issue the invitation and the worker, having the concern or raise the issue, attends. But the PCB refuses to attend. How do you treat that situation? Because it is further suggesting that if conciliation fails, it assumes a discussion or a deliberation in terms of conciliation. But if the PCBU refuses to attend, then we have a problem. No, I blame the PCBU in this case. I know where I want to place the emphasis. You see, the worker raising the issue is most likely willing to attend. But Member Campbell, representing, might give instructions to the PCB, you don't have to attend. You're not at liberty to attend. Because he was a party to these discussions and deliberations here, and he sees this very concern that I have.
Yes, Mrs. Seeley Brown.
Is there a reason why we are using the minister and not the director of Occupational Safety and Health to deal with this procedure? Why are we escalating to the level of a minister, of writing to a minister, when we are appointing a director of OSH?
Yes.
All right. When it comes, we're going back to the Labor Relations and Industrial Disputes Act, that this is resolution of industrial disputes. The director was an error in the bill, which we already came and corrected, because the person who you refer dispute to, is the Minister of Labor, not a director within the Ministry of Labor. The power, I know, but we're using, because we're going and utilizing the conciliation mechanism that is utilized, we're using the procedure that is there. And so it's not the director, so it was incorrect in the bill, so we came to actually correct that previously. Because it's really the minister's authority and the minister's jurisdiction that is being triggered, not a particular director. Because it was saying director conciliation, and conciliation is not dealt with by OSH. This is a direct conciliation department within the Ministry of Labor. And the training of an OSH officer and the director is not for conciliation. The expertise lies within our industrial relations department. So that is why we were correcting what was on the face of the bill, because that was incorrect to have said the director conciliation. It was not meant to be a power of the director OSH. But
yes. In respect of the concern raised by Member Gale.
Yes, we do. Well, we have to remember though that conciliation is voluntary. So we start from that point. Nobody can be compelled to attend conciliation. Now, when we had first come to the House, we really had, when we came to this committee with the matrix, we were basically saying if the parties fail and or refuse the conciliation meeting, the minister is to refer to the issue to the tribunal at any time after such failure and or refusal. That's what we had come with at first. So I think we have to look back at, and I know the committee had raised concerns, but I think we have to look back at how we worked that in, because that is why, it's because of that gap where we came with that proposal, knowing that persons may not come or one party may not come. But I was asked by the committee to go back nearer to the LRIDA, so that's why I went and looked. But I think I still have to work in what I had proposed in the matrix on page 33 and fit it into what we propose here. Because that is why we had made the change in the first place, the proposal, because there is that gap. So I will look back at what we had proposed in the matrix and try to insert it back in this document.
There's some clarification here. We were saying that the minister is required to act within 10 days of receiving the report. And so it pins the minister to a specific period of 10 days. If that does not within the 10 days, what next? Or what sanction do you have for the minister?
The minister would be subject to judicial review.
Yeah. Just to be clear, I think what Member Skeffrey is raising is some I've raised before. How does this move from the minister intervention, conciliation, to the tribunal? Is there any compulsion on the minister to send it? Or is it going to be again up to the minister whether he or she wishes to send the dispute to the tribunal? It's not clear in 4 that you have here. So that parties must move within a certain time frame. But after that time frame, nothing happens. The minister can take a year, 2 years, 3 years. May not even send it. What happened after? Dies with the minister?
We said is required for the reason that, as we had indicated before, it was not a discretion that was being given to the minister in relation to these OSH matters. Because, and the same thing with reprisals, you did not give a discretion because of the nature of the issues is that you did not give a discretion. So it's not the may that is in the LRID. That's why we're using the is required.
So where would we find that requirement that the minister shall send this? It's tied to which clause?
What we were using is the minister is required, because if you know what I was saying, is required within 10 days from the date from which a specified period expires to invite the parties to conciliation meetings, and if conciliation fails before the institute tribunal for set resolution, that required was meant to cover all of that situation. So I did not say shall, but shall would be what would be appear in the legislation as opposed to may.
So you want that the minister has no discretion? So why not you shall?
I wasn't drafting the bill, I was setting the policy. So when I put is required, it was to trigger
so the drafts will do...
To travel that I did not want a discretion.
But secondly, following up on Member Brown's point, though he shall refer to the tribunal, there's no time frame in which to do so. So he shall, but...
Within 10 days?
He can keep it on his decks.
Within 10 days of receiving his report?
It was intended that the 10 days is to cover all of that period.
No, during the...
Problem you have?
No, he's
Sorry, go ahead.
To the conciliation meeting, and when conciliation fails, refer the issue to the tribunal. So as I read this, he has to invite them to a meeting within 10 days and try to have a resolution. But if there's a breakdown in that process, he refers to the tribunal, but there's no time frame in which the minister should. So it's not within the 10 days. Within 10 days to start a process, as I read it, So during the period of 10 days.
It does not cover the intent, because the intent was for all of this to happen in 10 days. So maybe we have to see how we have expressed it, but it was the 10 days for everything that was envisioned.
And back to the point that was made by Ms. Seeley, bro. Remember, he's a minister in charge of policy and thing. Do we know does the minister have, is the intent that the minister can delegate this authority? Is the intent that the minister can or may delegate this authority? Because if that's not the case, this won't be practical. Let's face the music and dance to it.
Mr. Seeley Brown, why you
yes, use the mic, yes.
He's going to need technical guidance, which is what I think happens under the industrial dispute.
Yeah, I know the guidance. I respect that. But as it is read here, he's still in charge. So I'm saying, while I get the guidance, but is a station that is referred to the minister, but the minister can say, okay, the director, you can deal with that to the full case and don't have to sit in the meetings and so on. Is that intent? Because if that's not the case, let's face reality. 10 days for this administrative procedure for a minister in charge of policy won't be practical.
I can only...
Yes,
I can only speak to what happens now, because even though legislation says the minister only sits in certain conciliation meetings at a certain level. That is why there's a whole team of the Industrial Relations Department and conciliation officers. At the time when they would have actually been having the conciliation meetings, they would be keeping the minister in the loop as to what is happening. At the time when conciliation has broken down, the minister would have written to the minister or discussed with the minister, referring the matter to the tribunal. And then the tribunal would have given directions for the referral to be made.
Chairman.
Sorry, minister.
Yes,
give directions for the referral to be made.
We already have a system that works. And I think that's what you want to pattern. And maybe the drafting instructions, which is what I'm reading these to be, so that the drafters will have regard for that. But it's not so much a minister who's going to be in the day-to-day thing. It's the conciliation department So maybe that's how we need to look at the LRIDA now and take that thing. What I don't want us to do is to put impossible conditions. Because, Chairman, when we in 74, 75, when the LRIDA was drafted, the idea is that the LRIDA would conclude in 21 days. And one judge who became later in Court of Appeal said it was a quid pro quo for people giving up the right, the freedom to strike, because the matters would be settled in one day. I'm hearing now of cases at the tribunal where the parties have finished the case and are awaiting judgment longer than a year, which is not good. And this could easily become part of that backlog. So we should avoid putting down too strict a condition, and to the discretion that has been taken from the minister. I cannot support that. If there's a dispute, let it go there. Let it go to the tribunal. The problem I have is the speed. All right? Is the speed. That's one of the issues that I have. So maybe, again, some discussion between Ministry of Labour, legal people, the drafters could clear up this having regard for the LRIDA. And then I want to make a comment on 5.
Yes,
Chair, if I may,
Soldier.
just going back to from 4A, I wanted to understand what is the agreed procedure. There's this reference to an agreed procedure. What is that? It doesn't even say. It doesn't even say if it's in writing or not, which really it would have to be. But where is this agreed procedure? Is it in the contract? Is it in terms of employment? I don't know. It's not clear.
Yes.
The default procedure is a little clearer since it says the default procedure would be prescribed. So I take it just as how we've had it in other laws where, you know, you leave it to employers to do something, and if they don't, then you have this fallback. But what is this thing that the employers must do? There would need to be clarity on this agreed procedure.
Chairman, just on that quickly. In the LRIDA, there's a where there's no agreement as to contract, the following grievance procedure would follow. I take it that this is what is intended here.
I understand that, but I still think there needs to be clarity on what is this agreed procedure in the first place. It doesn't say it must be in writing. It doesn't say agreed between whom exactly. I'm just saying it can't be left the way it is.
This is imperfect could be too nice a word for this. This is raw. And that I think what they're saying, and tell me if I'm wrong, is that the drafters must now fashion this. This is like drafting instructions.
Right, but the drafter cannot dream up the policy behind what is an agreed procedure, because those are very specific things. So, for instance, if it must be in writing, then the ministry would have to say so. It's not for the drafter to define the policy and then draft that own policy.
Yes.
A procedure like this should be in the bill.
Very well.
I
Mrs. Bennett Campbell.
Okay. The agreed procedure refers to the agreement in either your contract or your collective agreement. So we will specify that is what you could have. Procedure agreed in your contract or in the collective agreement between the parties.
Sorry, I don't understand that. It must be implied through the bill. It must be implied in all contracts. It has to be in the bill. It has to be in the bill. That these are the mechanisms for resolving this.
Chairman.
Yes, Member Gill.
I wouldn't want to put a burden on a person conducting business to draft these terms in a contract of employment. And it is not yet at least, every employer having a trade union to represent them. But we'll make ourselves available. I strongly encourage, it comes first. I strongly encourage that this particular procedure that we're speaking of must be outlined in the legislation, where the reference can easily be made, so that there is no doubt created in anybody's mind. Matter of fact, there are certain aspects of this legislation, that it will not hold up without having these particular guidelines. Not going to hold up, because they would be considered as the reference point. You don't want a situation where an employer or person conducting business, or even the worker for that matter, saying to us, so we're supposed to do this, but what am I going to do? Where's the first place I must look?
Very well, Member Gale. Ministry? Yes?
We will look nearer to Section 6 LRID to recraft it. Not exactly in the same way, but in terms of setting out an implied procedure like it did there.
Very well.
And then if you don't, and then you should at least adhere to the implied procedure. At least that should be covered in your collective agreement or contract. So I think we'll take the approach that is in Section 6 but modified for our purposes.
Very well.
I'm thankful that they're prepared to take that approach. But I think your ministry need to be aware, and we keep saying it lest they don't feel offended. But there are some lawyers who set out to set back the progress made in providing rights to the workers of the country. And I've seen, and they are so persuasive in front of some judges, and I'm mindful of the standing orders, that judges are prepared to say, if the law didn't say you can go through the tribunal, then you can't claim through the IDT your redundancy. And there have been 2 cases recently, Chairman, that I am sure the Ministry and the Attorney General's Department are aware of. And we hope that instruction will be given to appeal those cases. But we, in crafting these legislation, and this one in particular, that empowers workers, we have to be sensitive that if the law does, if it's not abundantly clear in the legislation, it could easily be challenged, and we might find some judge who is prepared to say, though it is not forbidden, you can't do it, which is kind of strange to me, because I was reading something the other day, it says, that which the state is not allowed to do is prohibited, but that which a citizen is not prohibited from doing is allowed. But somehow the judges seems not to buy that view. And so I want to make sure that in this legislation, we make it clear that things that are not prohibited by the Act is allowed to be done.
Yes. The point is taken, Member Brown. The Ministry will revert to the committee as to the way forward in respect of this matter. Yes, Alden, you had any further?
I was just talking with Mrs. Seeley Brown, because I have to tell you, I'm looking back and the timeline, I'm really not following the timeline. I'm wondering if maybe a sort of bullet point could be done, or numbering, or because to have to go back, so you read 4B, you have to go back to A, then you go to 4C and you go back to 4B or 4A, and then you go to 4D, you go back to B. And I'm still not sure about when all the different 10 days, because I don't think it's the same 10 day. It's different 10 days being triggered by different things. And I'm really not clear on this timeline at all. And I know that is what Senator Brown was getting at, but it's becoming less clear to me the more I read it. So I was just wondering if maybe there could be a sort of number 1, 10 days from, you know.
It's like a grievance procedure. It's like a grievance procedure with different steps. And again, I go back to is it clause 6 in the LRID that kind of said this is the implied in all contracts condition thing. But I take a timeline issue, and it's something that, again, consultation between the different agencies could resolve it, because it's like first step, second step, third stage. It's that. But Chairman, I want to raise up issue about 5 if we're finished with 4.
Yes.
Yeah. Again, it may be a question of just the language, but tribunals now make award. And that's what the IDT does. This is saying, I don't know if there's why there's a preference for order and declarations, which are things you get sometimes from the courts as against the award. And to give such directions as are necessary, it sounds like a CPR.
No, I think it is having regards to the nature of the matter that the tribunal will consider. And I take the point, and I'm sure Mrs. Benny Campbell will comment, but we're dealing with occupational safety and health matters here. It's not like
we're dealing with occupational health and safety disputes.
Yes.
So we will not have awards.
I'm sure that is likely to be a consideration, but there are other things which may take the form of directions.
But Chair, clause 111 of the bill uses the word awards. I'm wondering, was number 5 intended to replace what's in the bill? I just took it that number 5, which really has no kind of detail in it at all.
Yes.
I didn't think it was going to replace what was in the bill, because you have way more detail in the bill.
Mm-hmm.
And I just thought it was just for completeness that it was added, but I guess the ministry who formulated the document can speak to it.
Yes. Mrs. Benny-Campbell.
111 was dealing with reprisals, so you would have had a termination, a suspension, or some kind of action. In this particular section, we're talking about giving directions, for example, to assist the parties in resolving the issue that is referred, in terms of what are the measures you can put in place. So it's not necessarily it's not really a monetary compensation situation that is envisioned here, because you're having an issue and certain steps can be taken to resolve it. So we kind of look nearer to the Disabilities Tribunal under the Disabilities Act in relation to this, because it's not like termination like under the LRID or something like that. It's just that certain directions could be given to assist you in resolving this.
Yes,
Chairman,
Sergeant.
We're going to have one tribunal that has different powers depending on where the complaint issue dispute arises from. I have to tell you, I really don't see how we couldn't support that approach. We really couldn't support that approach.
Yes. Mrs. Benny-Campbell.
The challenge we're having is that if we take just what we have before, where you're going to reinstate the worker, re-engage the worker, it still needs something a little more here, because it may not be that one of those actions has happened. Because the reprisals that we were talking about, it's different.
Mm-hmm.
So if they're to give directions for you to resolve the issue.
Mrs. Seeley Brown, do you have any suggestion to help resolve this matter? Yes. Yes, Mrs. Seeley Brown. Yes, no, I'm inviting you. Having regards to the clause 111 that Soljan highlighted and what the ministry has indicated, do let, yes.
I want to make it clear that I don't even, that last sentence on 5, I don't even like it. The tribunal should be guided by what is reasonably practicable having regard to the circumstances of the case. And I don't know, we begin to prescribe the tribunal in a way that other legislation in other jurisdictions has done, but we have chosen thus far not to follow that route and to trust the tribunal who is appointed given the schedule of people with experience and so forth. So when I see things like this being introduced in the bill, reasonably practical having regard to the circumstances of the case, I kind of recall how prescribed the Employment Act in England is, that we don't have in our jurisdiction no. So that's something that they may want to consider. You trust the people we have appointed, right? And I'm not going to say whether they have ambassadorial quality or not. I'm not going there right now. But you know what I'm talking about.
You're Mr.
It has nothing to do with Southeast.
But to be clear,
yes,
I mean,
yes.
there really needs to now be certainty as to if there is one tribunal under the bill, what are the powers of this tribunal? That has to be very clear because those are things that can be challenged.
Yes.
What are their functions under the bill? Again, that has to be very clear. Things like the last sentence, I mean, remember that case law, we're guided by case law, everybody must act reasonable. And again, that is something that can be challenged if the tribunal does not act reasonably. But if the thinking was that they don't want to use a construct that is currently in the bill relating to the tribunal, then what is in number 5 is woefully inadequate.
Yes, yes. I think the point has been taken. The ministry will come back to the committee. You have a further comment? Yes.
Then I really wonder if this is the intent of this tribunal, why does it have to go to a tribunal? Why would it have to go to a tribunal? If this is what, look back at number 5. Why does this have to be a tribunal then? This doesn't seem like to me tribunal worthy work. Based on what I see before me in number 5, which is why again, I really made an assumption that this really couldn't have been it and this is not replacing what is in the bill. I'm not clear.
Yes.
Chair, usually in my mind, when there's a concept of a tribunal in any legislation, I usually look at the schedule that outlines the particular guidelines of how the tribunal is set up, the composition of the members of the tribunal, and how the tribunal ought to operate. I may have missed it, but I am not seeing it in this piece of legislation. Eh? Well, I don't know, Member Brown. I don't know if under these circumstances that prevails today, whether or not the Industrial Disputes Tribunal is going to be able to take on all these issues, or is it a proposal to have expansion of the divisions of a tribunal to satisfy these particular needs? But when I say 5, usually a tribunal also would make its own rules in terms of how it operates. But this is seeking to determine from the onset.
No, it has to be judicious.
Determine from the onset how it is going to either make its orders, its declarations, or what is referenced in the legislation in terms of the awards. Well, no, I'm still trying to be clear in my mind if it's the Industrial Disputes Tribunal or we're proposing to set up a different tribunal.
Right, and Senator, if you look on page 16 of the bill, it had envisaged the IDT. It said tribunal means the USH division of the IDT established by Section 8.1. That's why you wouldn't have found anything in the bill. But I thought there was some discussion later on where there was some debate about whether it should be the IDT or not, and I'm really not sure on whether it's a completely different tribunal being established now, or we're still using the IDT, and then based on number 5, whether we're going to have 2 separate tribunals or not.
We have been having a number of meetings.
Yes.
The mind is not the sort that we are going to be able to retain some of these discussions.
Yes.
But I can recall a concept, Chair, of based on what may come out of the plethora of issues that we might have to establish a separate tribunal. And it's the same thing with another piece of legislation that we're dealing with now, the sexual harassment bill, that is proposing a separate, distinct tribunal to deal with this. Because I'm putting it to you, Chair. The present tribunal cannot treat with, it's already overburdened, and cannot deal with all these things that may come. And some of these issues will require a swift award or declaration or order, whichever instruct. But this is saying that is whichever instruct we might agree on.
Excuse me, may I come in for just a minute?
Yes, you may.
All right, in the 10th schedule is where we were trying to create the USH division of the tribunal that we had, and we would have been making consequential amendments to the LRIDA. So what was being proposed in 2 is a deputy chairman, occupational safety and health, appointed by the minister after consultation with organizations, and then there would be other members of the tribunal. So while it is the Industrial Disputes Tribunal, we were not envisioning using the same persons because we need persons now with expertise in occupational safety and health. And the LRIDA allows you to actually establish different divisions.
So if you permit me, Chair.
Yes.
The tribunal in number 5 on the paper was supposed to be still the same division of the IDT?
The Occupational Safety and Health Division of the IDT, which would have been established.
Yes, Aldrin, you want to speak through the mic?
Clearly, Chairman, let me say it. It's a new tribunal, and probably a different tribunal, and we're just putting it underneath the IDT heading. So that is a policy issue that needs to be worked through as to whether it's going to be
by itself,
or it's going to fall under the IDT. And so I'd wish that to be resolved by the ministry. And are we going to have a USH Division West, USH Division Central? Because that's the model we have now for the IDT. So it needs to be worked through and come back to us.
Certainly.
And I was beginning to think, Chairman, that the recent addition to the tribunal was to deal with this. But nobody wanted to tell me there's an additional chairman.
I do not have that information either. Mrs. Bellingcamp, yes?
Yes, and the tribunal the committee has gotten to something that we have been grappling with as a ministry, as to whether it is going to fix neatly into this mold that we have here in terms of the IDT, or is it that we need a new tribunal? Now, we were actually trying not to establish a new tribunal, but it's not seamless. And we recognize it's not seamless. So that is something policy-wise, we are definitely willing to consider, because the more we try to fit it into that mold, it becomes more and more difficult. And when we get to the 10th schedule, it will become even more difficult.
All right. So in respect of what the ministry has put forward here under point 4, certainly the ministry has to come back before the committee with greater clarity, so that our members are clear as to the mechanism that is being proposed. So the ministry, in respect of 80 to 82, we have to come back again. It is now 120 members. Yes.
Issue. I just listening today begs for the coming together of the teams again, because it's clear to me that, let me give you an example. In one of the things we discussed earlier, the AGC had a view, but it had not yet been communicated to Labour. So we have to revert. Then now there are issues like the tribunal, for which not just us in the committee have found issues, but the ministry themselves isn't clear, and the legal people not sure where the ministry going. So again, I beg for coming together of the teams from the government, one government, the teams from the government, to come together and resolve issues, so it make it easier for the committee to say yeah, nay, or so, rather than we're catching the animals and then come afterwards and make the sausage.
Yes.
We are to make the sausage, but we can't be out there running down the animals to get the parts of the sausage.
Just to know, though, Member Brown, that there are issues of policy that that needs clarity in a number of cases. So I guess once those are settled, then the parties, the lawyers who have demonstrated a willingness to meet, I'm sure there can be a meeting thereafter. Members, the date for the next meeting has been proposed to be Thursday of next week. Monday is a difficulty for me. Yes. No. So Monday is a difficulty for me. Yes, next week, Thursday at 10. March 12th at 10 a.m. We will. Yes. The 19th. Not the 20th. So we will go on till 1 next week. Yes. So we also have the 15th. Yes. We have the 15th. Oh, sorry. The 16th. The 19th. The 23rd. The 26th. The 30th. We anticipate that the 23rd is, yes. 23rd, the 26th.
All Mondays and
All Mondays, all Thursdays. 26th and 30th.
23rd, 26th, and 30th. Yes.
We didn't hear the dates.
Well, save and except Monday the 9th, we are doing Thursdays and Mondays for the month of March.
Except
Yes.
for Monday, which is
All at 10 a.m. Yes.
Oh, except for next week.
Yes, duly noted. Mr. Basco will represent. And Ms. Thompson will represent. Yes.
Mr. Chair,
Yes, Mr.
just to
Simmons.
clarify, the dates you have are the 12th, next week Thursday,
Yes.
16th, 19th, 23rd, 26th, and then 30th?
Yes, that's all. Good. May we now have the adjournment? Seconded by Member Campbell. This meeting is now adjourned.
Jamaica, land of wood and water. That's Jamaica, once covered with lush forests